Your Honour, my name is Stephen Ramesh, acting on behalf of the applicant, Mr. Walter Liu. The nature of today's application is to seek an injunction to prevent the respondent, Mr. Robert McGedden, from continuing his harassment campaign against the applicant, and this is pursuant to Civil Procedure Rules 25.1 and several selected provisions of the Protection from Harassment Act 1997. Throughout the course of my submissions, Your Honour, I will be relying on several documents in order to aid me, and these can be found in paragraph 2 of my skeletal argument. They are the draft order for an injunction by the applicant, dated the 10th of March 2020, the applicant's draft particulars of claim, the witness statement of Mr. Walter Liu, dated the 9th of March 2020, alongside counsel's skeleton argument. May I check, Your Honour, that Your Honour has read these documents and has had a chance to go through them? Very well, Your Honour. In addition to these documents, I will be relying on several cases in order to aid me. They are the case of Con against Sunderland City Council, the case of Jones and Ruth, Hall and Stock New Church Guinea Pigs, Patel and Smith, Garden Cottage and Milk Marketing Board, and the case of NWL against Woods, which will be which I will go through one by one throughout the course of my submissions. Before I begin, Your Honour, allow me to briefly recount the facts for the court's convenience. The applicant is the proprietor of several health clubs under the company Liu Valley Health Limited. He operates two health clubs alongside his wife, and they are the Liu Valley Spa and the Farnaway Health Club. The respondent was a former employee of the applicant's, one of the applicant's health clubs in which was known as Liu Valley Spa up till 2018, when he was terminated by the applicant due to a verbal argument that they had between the pair. The respondent then began a campaign to harass the applicant, clearly upset at the fact that he was terminated from his employment, and this occurred over a period of 6 months from the date of his termination. This included a combination of various verbal threats and also a physical assault that happened throughout in 2019. The respondent has also directed several threats at the applicant's son, Mr. Peter Liu. The applicant therefore has applied for an urgent injunction without notice in order to prevent the respondent from continuing his harassment campaign against not only himself, but his son and his businesses. Your Honour, I understand that this current application is made without notice. However, Your Honour, there is several good reasons as to why this application was made without notice, and the fact, taking into account the fact that the respondent is not here to oppose the current application. The applicant averse to the fact that the threats that were made to incite and commit violence against the applicants are serious in nature, and therefore there was no other choice but to put forth a application without notice in order to get an injunction to protect Mr. Walter Liu's security and his interests. The respondent is unrepresented and is not present for this current hearing today. However, the applicant still urges the court to consider this case fairly and to take into account the circumstances that have befallen the applicant due to the respondent's clearly malicious campaign of harassment. My instructing solicitors on behalf of the applicant have made several attempts in order to contact Mr. McGedden in order to inform him of the date of today's hearing, but have been unsuccessful to do so. They have also personally attended to his last known address on file and have served a copy of the witness statement of Mr. Walter Liu. However, Your Honour, unfortunately, upon personally serving the copy of the witness statement, my instructing solicitors was met with a woman who has told my instructing solicitors that Mr. McGedden has not stayed in that address for about 2 years. Nevertheless, Your Honour, I submit that the application should still continue in the interest of justice and also in order to protect Mr. Walter Liu. The applicant urges the court as a matter of urgency to allow the granting of this application before the issuance of the claim form. I note, however, Your Honour, that the claim form has not been issued yet. However, the applicant is willing to provide an undertaking to issue not only the claim form but the particulars of claim as well, as soon as the court is done dispensing with an injunction today. The applicant is also willing to provide a undertaking in damages to compensate the respondent if he so suffers any damage due to the granting of this application. Your Honor, I will now move on to my submissions proper, and I will concentrate on the Protection from Harassment Act 1997 first. Your Honor, it states in Section 1 of the 1997 Act that a person must not pursue a course of conduct which amounts to harassment of another. Section 7 of the 1997 Act defines a course of conduct as conduct on at least 2 occasions relating to a single victim and only 1 occasion in relation to 2 victims. Now, both of these courses of conduct are clearly seen in our current case, Your Honor, as not only has Mr. Megaden targeted Mr. Walter Liu, but he has also targeted his son as well on a few occasions. Therefore, it is submitted, Your Honor, that the action of the respondent in making death threats and physically assaulting Mr. Walter Liu does indeed amount to harassment pursuant to Section 1, and therefore this allows the applicant to seek a civil remedy pursuant to Section 3 sub 1 of the Protection from Harassment Act 1997. Now, Your Honor, if I may turn Your Honor's attention to the case of Con against the Council of the City of Sunderland, decided in 2007, which is located in the list of additional cases that I have provided the court earlier. May I turn your attention to Your Honor's attention to paragraph 12. The court states that injunctions would be granted in the cases of harassment if the conduct of the respondent is oppressive in nature and possesses sufficient gravity to attract criminal sanctions. It is submitted that in our current case, Mr. Megaden has been arrested twice for his various actions against the applicant, and therefore it is severe enough to attract criminal sanctions, and the court should consider this to be a serious problem in order to grant an injunction. The applicant urges the court that each of these situations have amounted to harassment, and there have been no less than 6 incidences where Mr. Megaden has verbally threatened Mr. Walter Liu. Therefore, Your Honor, it is the applicant's submission that the respondent is liable for all injuries that have flowed from the course of his conduct, particularly the amount of mental distress and anxiety that Mr. Walter Liu has faced so far. Your Honor, moving on to my second point of contention, that the court should consider the facts of American Cyanamide against Eticon in order to decide whether an injunction should be granted in our current circumstances. It is our submission at the start, Your Honor, that the court should address and grant the applicant an injunction to prevent him from being harassed by Mr. Megaden, because there is a serious question to be tried, and damages would not be adequate for the applicant, but would be adequate to compensate the respondent. If the court still is unable to decide, the balance of convenience clearly lies with the applicant, and as a last resort, the status quo prior to the respondent's campaign of harassment should be upheld. Your Honor, in relation to the serious question to be tried, may I turn Your Honor's attention to page 2933 of the White Book, paragraph 15.7, where the case of American Cyanamide lays down several principles that the court should consider. When considering whether there is a serious question to be tried, the court should see whether there is no rule or practice to the effect that the court is not entitled to take into account the balance of convenience, and secondly, that the court must be satisfied that the claim is not frivolous nor vexatious. It is submitted today that the application is not frivolous or vexatious, and this is a low threshold that the applicant clearly has managed to reach, and is fulfilled by the fact that a respondent has been arrested on 2 occasions, for one, for making death threats to the applicant and his son, and secondly, for assaulting the applicant. Your Honor, this can be found in paragraph 21 of Mr. Walter Liu's witness statement, and as to the arrest for assaulting the applicant, this can be found in paragraph 33 of his witness statement. Your Honor, there is clearly no defense on behalf of the respondent for his actions, and therefore to deprive the applicant of an instant remedy would be a misuse of the court's process. There is no arguable case for the respondent in order to give a reason for his campaign of harassment, and therefore the questions of the balance of convenience, status quo, and damages being an adequate remedy do not rise. This, Your Honor, is stated in the case of Patel and W.H. Smith, decided in 1987, and this can be found in page 7, the third paragraph from the bottom. Your Honor, if the court considers that there is a serious question to be tried, however, then the court should look into the adequacy of damages for both parties. It is submitted at the start that damages would not be an adequate remedy for the applicant, but would be an adequate remedy to compensate the respondent for any harm that he suffers due to the granting of this application. This is because, Your Honor, that the respondent's actions are clearly out of the ordinary course of actions for any reasonable person, and the applicant is also willing to provide an undertaking in damages in order to compensate the respondent. The reason why the applicant receiving damages would not be adequate is because his way of life has been severely disrupted by the actions of the respondent. He has suffered severe injuries due to an assault by the respondent and fears for his safety whenever he travels, and also fears for the safety of his son and his businesses. Therefore, it is clear, Your Honor, that damages would not be an adequate remedy for the applicant. The court should then consider the balance of convenience, and it is clear, Your Honor, that the balance of convenience clearly favors the applicant, as he has been victimized by the respondent's harassment and seeks an injunction in order to protect his safety and security. The applicant would be severely prejudiced, Your Honor, if the respondent is not restrained from his malicious activities, and if his actions were to continue. The respondent would not be prejudiced because, as I have mentioned previously, Your Honor, his actions are unreasonable and malicious and are deliberately as a result of him being terminated in 2018. However, if the court is still of the mind that the balance of convenience does not clearly shift to the applicant, then the court should consider to uphold the status quo, which was the conduct of both parties before the respondent had his employment terminated. And now this status quo, Your Honor, is the state of affairs before the claim was initiated, and this can be found in the case of Garden Cottage Foods and Milk Marketing Board, decided in 1984. Your Honor, I note that this application would serve as a final disposal of the claim, as if the application is granted, there would be no claim for the applicant to put forth. Now, the court should consider an additional test in order to ensure that the applicant does indeed satisfy the requirements of the court for a final disposal hearing. The applicant does indeed have a high degree of likelihood of succeeding in establishing his claim due to the submissions that I've made previously, and due to the fact that the respondent has been arrested on several occasions for his actions towards the applicant. Your Honor, if I may turn Your Honor's attention to page 2938 of the White Book, to the case of NWL against Woods, and this can be found in paragraph 15-18, where the court stated that the degree of likelihood that the plaintiff would have succeeded in establishing his right to an injunction if the action had gone to trial is the measure that the court should take when considering final disposal hearings. Your Honor, in conclusion, the applicant clearly seeks a remedy in the form of an injunction to restrain the respondent from continuing his harassment campaign against the applicant's son, and also his business interests, being the two health clubs that he runs with his wife. The applicant has made this application due to Section 3.1 of the Protection from Harassment Act 1997, as he has been harassed by the respondent for a period of 6 months. The court should grant this application as soon as possible and grant an interim injunction to prevent the respondent from continuing his actions further. Your Honor, if I am unable to assist this court any further, this will conclude my submissions. Thank you.